All right, the verdict appears to be in proper form. Ms. Gregg, if you and your attorneys would come to the podium. The verdicts read as follows. As to count one, we, the jury, sentence the defendant Carly Madison Gregg to life imprisonment. As to count two, we, the jury, sentence the defendant Carly Madison Gregg to life imprisonment. Please be seated.
That was the moment that then 15-year-old Carly Gregg, now she's 16, just had a birthday, was sentenced to life in prison for killing her mother. Well, now she's seeking an appeal, and she's pointing to her age as a key reason for it. Gregg's attorneys are arguing for a second time that the jury was given incorrect instructions before their deliberations, saying in part in their recent filing, quote, the court's instructions letting the jury toggle parole on count one, which was first-degree murder, were therefore ultra virus, and the life without parole sentence is count number two, likewise infirm for a juvenile. None of this is harmless. It goes to who decides what options legally exist and how youth must be considered. The filing going on to say the prosecutor suggested that if Carly received a parole-eligible sentence, she could be out in as little as a year, an assertion that is not only patently false, it also is misleadingly reframed the stakes. Okay, so does Gregg's appeal seem viable? Bottom line, is it gonna go anywhere? Let's ask our legal eagles, Casey Early, Franz Borgard on the show. Casey, what do you think, please?
Julie, if there was constitutional errors, if she was denied a fair trial and the instructions were not proper, then she should be granted a new trial and the proper instructions given. But if it's just solely because of her age or that the defense wants a do-over because they didn't get a chance to adequately investigate the case. There was some allegations that this was a rocket docket, that she was brought to trial within 6 months. I mean, there's motions that you can file and argue to the court if you need additional time. Just because it's set in course doesn't mean you have to go within the 6 months. So if they're arguing that they did not adequately prepare, then that may be a reason not to do a new trial.
Sure. Franz, what do you think about this? Does this appeal and the grounds sound like it's going to hold water to you?
I think that she has a viable argument for an appeal. I don't know if it's going to hold water. And look, the best thing that she has going for her is her age at the time of this trial and the time of the conviction and the time of the sentencing. Our Supreme Court has decided, for better or for worse, that juveniles are treated differently than adults. We treat them differently because they're not as developed. It doesn't mean they can't be convicted. It doesn't mean they can't have consequences. It means they get treated differently. And these are straight-faced arguments. What do I mean by that, Julie? It means that they're not like frivolous. They could have weight to them. They could work. And look, anything she's doing right now is to put herself in a better position, either a better sentence, maybe a negotiated resolution. Parole eligibility would be a huge, huge golden ticket for her. And if I was representing her, that's the North Star, is parole eligibility at some point.
Sure. No, you're right, Franz. Let's take a listen to the 911 call. Remember, she's covering her ears so as not to apparently face what she had done.
We got everybody. She what? She killed her mom. She killed her mom? Yeah. That's what I'm screaming about. Where's the mom? When I do this, she doesn't kill me.
Now, Carly Gregg's defense team is also pointing to a rocket docket, they're calling it, and trial scheduling. They're claiming that this also denied her a fair trial. They're saying in the same filing, quote, in a case of this magnitude requiring collection and review of extensive medical and mental health records, multiple evaluations, substantial family background history, and a dispute of motive, such acceleration is extraordinary in Mississippi criminal practice. The compressed timeline set in motion when, at the first pretrial hearing, the trial court announced, quote, it does not continue cases, together with erroneous and unconstitutional pretrial orders, deprived the defense of a fair opportunity to prepare. Now, Now, Carly Gregg's team was denied their first attempt at an appeal. The court ruled that the defense had enough time to prepare, and their claim of trial by ambush did not work. Okay, so what do we think about that idea? The rocket docket, was this the problem? Franz, what do you think?
I think we're seeing them put everything in the kitchen sink. And I think that it's not as good of an argument. Now, look, that said, I'm a big fan of, if you want to hunt for justice, make it a fair fight. And there shouldn't be a rush. If the defendant is trying to use constitutional speedy trial rights, that's different. But she's incarcerated. She's not going anywhere. The public is safe. So I get what they're arguing. I just think that this is a cherry on top kind of situation where it's not going to really make or break the appeal, but they need to allege it so that they can have a holistic package of the appeal.
Sure. You know, another question we were talking about in our newsroom this morning, was her defense believable? So was she insane at the time of the shooting? For anybody who needs a refresher on this, we've got some clips from the medical experts. Let's take a look at that. And Casey, I'll come to you on the other side.
Your opinion ultimately is that from the time that she got home and she took out the dogs, that she blacked out at that point, correct?
Yes.
And that she doesn't come to until the police pick her up, correct?
Correct.
But she remembers everything else that day.
Yes.
She remembers waking up and being irritable that morning.
Yes.
But that one hour or so period, an hour and a half period, that's the period that she doesn't remember.
Correct. My opinion is that Carly does not meet Mississippi's standard for insanity at the time of the offense, and that she knew the nature, quality, and wrongfulness of her actions during that day.
Okay, Casey, doing criminal defense work, curious if you think that was a smart defense that they put forward for her.
That was the only defense that they had, right? Because we know that this was captured on surveillance. And then it's what she did afterwards. I believe that she called her friend and told her, her friend that, do you want to see a dead body? She even texted her father and, you know, tried to figure out when he was coming home to attempted murder as well. So what she did, she had no other viable defense. It was captured on camera. Now, had this not been captured on surveillance, that would have been excellent, because what child does this to their parent? She was in such a young, innocent age, but she had no other outlet. And I do agree with the second doctor's evaluation that this wasn't a case of temporary insanity. This was her only option left, and it wasn't believed by the jury.
Casey, thanks so much for that. Franz Borgert, thank you to you.